hospital trap that bankrupts seniors, and the 1930s, law that still protects you. Here is the promise of this video, right up front, no waiting. There's a trap hiding inside almost every hospital in America. It doesn't look like a trap. It looks like care. It looks like kindness. A nurse hands you a blanket. A doctor tells you, "We're going to keep you overnight just to be safe." You say thank you. Your family says thank you. And 3 days later, you walk out of that hospital owing more money than some people make in a year because of one word that nobody explained to you. And here's the second half of the promise. There's a law, a real one, passed back in the 1930s during the worst financial collapse this country has ever seen, when millions of families were losing everything at once. That law is still on the books today in some form in almost every single state. Most people have never heard of it. Most people don't find out it exists until the collection letters have already started arriving. But if you know about it, if you know it before the hospital bill lands on your kitchen table, it can be the difference between losing your home and keeping it. We are going to tell you exactly what that law is and exactly how it works by the end of this video, not before. Because you need to understand the trap first, all the way through, to understand why this old, dusty, almost forgotten piece of legislation matters so much right now in your life, maybe this year. So stay with us. Somewhere in the next few minutes, a woman named Ruth is going to lose almost everything she owns, and then we are going to show you the exact tool that could have stopped it. Section 1, the word nobody explains. Ruth was 74 years old. She had lived in the same small house for 31 years. She had raised 2 kids in that house, buried a husband from that house, and planted a garden every spring in the backyard, right along the fence line, because the morning sun hit that spot first. One Tuesday in October, Ruth felt dizzy in her kitchen. Her chest felt tight. Her daughter, Angela, drove her straight to the emergency room, hands shaking on the steering wheel the whole way, praying out loud without really meaning to. At the hospital, doctors ran tests. They wanted to watch Ruth closely. A doctor came in and said the words that so many families hear and don't think twice about. "We're going to admit you for observation, just to monitor your heart overnight." Admit you for observation. It sounds like being admitted. It sounds official. There's a hospital bracelet. There's a hospital bed. There's a hospital gown, the kind that ties in the back and never quite covers what it's supposed to. Ruth stayed in that bed for 3 nights. Nurses checked on her every few hours. She ate hospital food off a hospital tray. In every way that matters to a person lying in that bed, she was a hospital patient. But in the language of medical billing, Ruth was never actually admitted at all. She was something else, something with a name most people have never heard until it's too late. Outpatient observation status. Here's the trap, laid out plainly. Hospitals in the United States use 2 very different labels for people staying in a hospital bed overnight. One label is inpatient. The other is outpatient, under observation. A patient in either category might be in the exact same room, on the exact same floor, hooked up to the exact same machines, cared for by the exact same nurses. From the patient's side of things, there is often no visible difference at all. But from the insurance and billing side of things, the difference is enormous. Being labeled outpatient instead of inpatient can completely change what your insurance is willing to pay for. It can change whether follow-up or rehabilitation care gets covered. It can change whether medications given in the hospital are billed differently. For someone on Medicare, it can even affect whether a later stay in a nursing facility gets covered at all. And the truly cruel part is this: the patient almost never gets to choose. The label is decided by hospital staff based on billing rules and medical criteria that are buried in policy manuals nobody in that hospital room has ever read out loud to a frightened family. Ruth didn't choose observation. Nobody asked her. Nobody explained it. The word was used once, quickly, by a tired doctor at 2 in the morning, and then everyone moved on to the next patient. 3 days later, Ruth went home. She thought the hard part was over. It wasn't. The hard part was just getting started. Section 2, the envelope that changed everything. 3 weeks after Ruth came home, an envelope arrived. Angela remembers the exact moment her mother opened it, sitting at the kitchen table, reading glasses pushed up on her nose, sunlight coming through the same window it always did. Ruth's face changed. Angela says she will never forget that look. Confusion first, then disbelief, then something closer to fear. The bill was for just over $18,000. Ruth had Medicare. She had always been told Medicare would take care of her if something happened. She had paid into that system her entire working life. But because she had technically never been admitted, because she had spent 3 nights in a hospital bed under observation instead, huge portions of her care were billed completely differently than they would have been for a formally admitted patient. Certain medications given during her stay were billed at outpatient rates instead of being wrapped into a covered inpatient stay. And when her doctor recommended a short stay at a rehabilitation facility afterward to help her regain her strength, Medicare refused to cover a single day of it because a specific rule requires patients to have at least 3 full days of inpatient admission before that rehabilitation benefit kicks in. Ruth's 3 nights in that hospital bed did not count, not one of them, because on paper she was never admitted at all. The rehabilitation stay alone came to almost $11,000 billed directly to Ruth because Medicare's rule simply did not apply to her situation. Combined with the hospital charges, Ruth was staring at a bill of nearly $30,000 for a single medical event that she had absolutely no way of predicting, preventing, or even fully understanding while it was happening to her. This is not a rare story. It is closer to a pattern. Every year, patient advocacy groups and Medicare watchdog organizations receive thousands of complaints from families who describe almost identical experiences. A loved one stays in the hospital, feels like an inpatient in every practical sense, and then is billed as though they were never admitted at all. Some seniors have described spending a week in a hospital bed under observation status before finding out, only when the bill arrived, that none of those days would count toward the coverage they assumed they had. For families already stretched thin, a surprise bill in the tens of thousands of dollars is not an inconvenience. It is a crisis. It can mean draining a retirement account that took 40 years to build. It can mean a second mortgage on a paid-off home. It can mean a senior citizen, someone who worked their entire life and expected to spend their final years in peace, suddenly facing collection calls, threatening letters, and the terrifying question that Ruth herself asked her daughter late one night at that same kitchen table. "Angela, can they take the house?" Section 3. When the collectors start calling for a while, Ruth tried to pay what she could. She sent in small amounts each month. She cut back on groceries. She stopped going to her weekly lunch with her sister because even that felt like too much of an expense. Angela offered to help, but Angela had her own mortgage, her own kids, her own bills. Then the calls started. At first they were polite, a representative from a billing office asking about payment arrangements. Then the calls came from a collection agency instead of the hospital directly. A sign, Angela later learned, that the debt had been sold or handed off the way unpaid medical debt so often is. The tone shifted. The letters got more formal, more threatening in that quiet, bureaucratic way collection letters always are. Phrases like, "before this matter proceeds to further action," started showing up in bold print. Ruth did what a lot of proud, independent people do. She didn't tell anyone how bad it had gotten. She didn't want to be a burden. She kept paying what she could and hiding the letters she couldn't answer. It was Angela who found a stack of them, unopened, in a kitchen drawer, months later when she was looking for a spare set of house keys. That is the moment fear really took hold in that family. Because unpaid medical debt, left unresolved long enough, doesn't just sit quietly. Depending on the state and the type of creditor, unpaid debts can sometimes lead to a lawsuit. A lawsuit can lead to a judgment. And a judgment, in some circumstances, can lead a creditor to attempt to place a lien against property a person owns, including, in the worst cases, families describe online in consumer complaints, the home itself. For an aging homeowner like Ruth, who had no mortgage left and one paid-off house as her only major asset, that possibility was terrifying in the most literal sense. Not, we might have to downsize, terrifying. We might lose the one thing my mother has worked her whole life for? Terrifying. Angela started searching everywhere for answers. She searched online late at night after her own kids were asleep. She called a legal aid hotline and sat on hold for 40 minutes. She talked to a coworker whose father had gone through something similar. And in one of those conversations, almost in passing, someone mentioned something Angela had never once heard in her entire life. They mentioned an old law, a law that had nothing to do with hospitals at all when it was first written, a law from a completely different crisis, generations earlier, aimed at a completely different kind of family disaster. A law that, this person said, might actually be the thing that saves your mom's house. Angela didn't understand it yet. Neither did Ruth. But that single sentence sent Angela down a path that would change everything about how this story ended. We're going to walk that same path with you. But first, it helps to understand just how many families are standing exactly where Ruth and Angela were standing. Because once you see how common this trap really is, the importance of that old law becomes impossible to ignore. Section 4. A trap that catches more families than you'd think. Ruth's story is not unusual. It is, in many ways, disturbingly ordinary. Consumer protection researchers and patient advocacy organizations have spent years documenting how common observation status billing surprises have become, especially for older adults on Medicare. Every year, hundreds of thousands of Medicare beneficiaries spend time in a hospital under observation status rather than formal inpatient admission. Many of them have no idea in the moment which category applies to them. Federal rules eventually required hospitals to notify patients within a certain window if they were being held under observation rather than admitted. A small step meant to reduce exactly this kind of shock. But even with that notice requirement in place, patients and families described the same experience again and again: a rushed conversation, unfamiliar terminology, and a genuine misunderstanding of what it actually means for the bill that follows. Older adults are hit hardest for a simple reason. They are the ones most likely to need hospital care in the first place. They are the ones most likely to need a follow-up stay in a skilled nursing or rehabilitation facility afterward. And they are the ones most likely to be living on a fixed income, with a paid-off home representing the single largest asset they have, and very little room in the monthly budget to absorb a surprise bill in the thousands, let alone the tens of thousands. Adult children of aging parents describe a version of this story constantly in online forums, support groups, and calls to elder law attorneys. A parent goes in for a fall, a fainting spell, chest pain, confusion, something frightening enough to justify a hospital stay. The family assumes, reasonably, that being kept overnight for multiple nights means being admitted. Nobody in the family thinks to ask the specific billing question because nobody knows that question exists. Weeks later, a bill arrives that makes no sense given everything the family believed about their coverage. Elder law attorneys who specialize in this exact issue often describe the emotional toll as being just as damaging as the financial one. Seniors who spent decades being fiercely independent suddenly feel powerless. Adult children who are already managing careers, their own children, and the daily realities of caring for an aging parent now have to become instant experts in medical billing codes, appeals processes, and collections law, usually while their parent is scared, and often while that parent is still recovering physically from whatever landed them in the hospital in the first place. This is the part of the trap that makes it so effective and so cruel. It doesn't announce itself. There is no moment where someone says, "By the way, this decision could cost your family $30,000, and there's very little you can do to stop it once it's made." It happens quietly, buried in a passing sentence from an exhausted doctor at an odd hour, and the consequences only reveal themselves weeks later in an envelope that lands on a kitchen table on an otherwise ordinary afternoon. But here is the important truth, the one that gives this story its turning point. While a family often cannot undo the billing decision itself once it's been made, and pursuing an appeal through Medicare in the hospital is absolutely something every family in this situation should attempt, with the help of a patient advocate or elder law attorney, there is a second layer of protection that exists independently of the bill itself. It has nothing to do with fighting the hospital. It has to do with what happens after the bill becomes debt. And after that, debt starts threatening the one asset a family cannot afford to lose, the home. That protection is not new. It is not some clever loophole a lawyer invented last year. It has existed in one form or another since the depths of the Great Depression, when lawmakers across the country looked at millions of families losing their homes to debt collectors and decided that some things should be harder for a creditor to take than others. That is the law Angela was told about. And it is the law we promised you at the very beginning of this video. Section 5. The 1930s law that came back to save Ruth's house. Here it is, laid out fully. During the Great Depression, home foreclosures and forced property seizures were happening at a scale the country had never experienced before. Families who had built their entire lives around a piece of property were watching creditors take that property away over debts that, in ordinary times, might never have spiraled that far. Lawmakers in state after state responded by strengthening or creating what are known as homestead exemption laws, legal protections, specifically designed to shield a portion, or in some states the entirety, of a family's primary home equity from being seized to pay off unsecured debts. Unsecured debt is the technical term for exactly the kind of debt Ruth was drowning in. Hospital bills, medical bills, credit card balances, debt that isn't tied to collateral like a car loan or a mortgage. Homestead exemption laws were built in large part in response to that Depression-era wave of family devastation to make sure that a roof over someone's head could not be so easily pulled away by unsecured creditors, even when a court judgment existed against them. Here is how it works in practical terms, and this is where it becomes genuinely hopeful for families like Ruth's. In most states today, a homestead exemption protects a certain amount of equity in a person's primary residence from unsecured creditors, both in bankruptcy proceedings and, in many states, in regular debt collection efforts outside of bankruptcy as well. Some states protect a fixed dollar amount of home equity. Other states, including a handful like Texas and Florida, protect the entire value of the home with almost no dollar limit at all, as long as certain residency requirements are met. Other states fall somewhere in between, protecting a moderate but meaningful amount of equity, often enough to keep an older homeowner like Ruth, whose home was fully paid off and worth less than the protected threshold in her state, from ever losing that home to a medical debt collector, no matter how aggressive the collection effort became. This is the piece almost nobody explains to families in the moment they need it most. A collection agency calling about a medical bill will rarely, if ever, volunteer the information that your home might be legally protected from their collection efforts. Their job is to collect money, not to inform you of the legal shields available to you. Many families, understandably terrified by aggressive letters and phone calls, assume the worst, that losing the house is not just possible, but likely or even inevitable. In reality, in the majority of states, a primary home with modest equity is far harder for an unsecured medical creditor to actually seize than families realize, precisely because of these Depression-era homestead protections still sitting quietly in state law books today. For Ruth, this knowledge changed everything. Once Angela connected with a legal aid attorney who specialized in elder financial issues, the family learned that Ruth's home, worth a modest amount and fully paid off after 31 years, fell well within her state's homestead exemption protection. Even in a worst-case scenario where the medical debt collector pursued a judgment against Ruth, that homestead protection meant the collector could not force the sale of Ruth's house to satisfy an unsecured medical debt. The house, the one asset representing an entire lifetime of work, memory, and stability, was never actually on the table to begin with, even though every letter Ruth had received made it feel like it absolutely was. That did not make the debt disappear. Ruth and her attorney still worked through negotiating the bill directly with the hospital's billing department, applying for hospital financial assistance programs that many nonprofit hospitals are required to offer but rarely advertise, and formally appealing the observation status decision through Medicare's appeals process. Some of the bill was reduced. Some of it was forgiven under a hospital charity care policy Ruth qualified for, based on her income but had never known to ask about. What remained was restructured into a payment plan Ruth could actually manage on her fixed income, without fear hanging over every single month. But underneath all of that practical work, one fact gave Ruth something she hadn't felt since that envelope first arrived: safety. Real, legal, documented safety. Her home, the house with the garden along the fence line, the house where she raised her children and said goodbye to her husband, and was protected by a piece of legislation written generations before Ruth was even born, by lawmakers responding to a completely different crisis, who could never have imagined a woman named Ruth, or a trap called observation status, and who nonetheless built something durable enough to reach forward across nearly a century and shield her anyway. That is the promise this video made at the beginning. The hospital trap is real. It catches good, careful, honest people who did nothing wrong except trust the system that was supposed to take care of them. But the protection is real too. It has been sitting quietly in state law for generations, waiting to be used by exactly the families who need it most, if only they know it exists before the fear takes over. Closing. What to do if this is happening to you or someone you love. If you or someone you love is facing a hospital bill that came from an observation status stay, or any medical debt that feels overwhelming, there are concrete steps worth taking in roughly this order. First, ask for a formal itemized bill and find out in writing whether the stay was classified as inpatient or outpatient observation. This single detail changes almost everything about what can be appealed and how. Second, if the patient has Medicare, look into the Medicare appeals process for observation status decisions, and consider contacting your local state health insurance assistance program, often called SHIP, which offers free, unbiased counseling to Medicare beneficiaries navigating exactly this kind of dispute. Third, ask the hospital's billing or financial assistance office directly about charity care or financial hardship programs. Many hospitals, especially nonprofit ones, are legally required to offer these programs, but they very rarely advertise them, and families frequently qualify without ever being told. Fourth, and this is the piece so many families never learn until it's almost too late. Look up your own state's homestead exemption laws, or speak with a local elder law or consumer protection attorney about how those protections apply to your specific home and situation. Many legal aid organizations offer free or low-cost consultations for exactly this purpose. And the peace of mind that comes from knowing your home is protected, even while a debt dispute is ongoing, is worth more than most people realize until they actually have it. Ruth still gardens along that fence line every spring. She still lives in that house. The bill took months of fighting, paperwork, and hard conversations to resolve, but the house itself was never truly at risk once the family understood the protection that had been there all along. That is the trap, and that is the law that still protects you. Share this with someone who needs to hear it before the envelope arrives at their own kitchen table.